Welcome to EPG Pathshala. I am Vijay Raghavan, Professor in the Center for Criminology and Justice at the School of Social Work, Tata Institute of Social Sciences, Mumbai campus. I am here to talk to you about Module 3 of the Social Work in Criminal Justice module, which is called Victimology and Crime Prevention. And these modules are part of the course on fields of practice within the discipline of social work subject. So what are we expecting to gain out of this module, which is on victimology and crime prevention? At the end of this course, the students are expected to understand how victimology began as a field of study and how it has evolved over a period of time, to understand the theories of victimology and crime prevention, to understand the issues of victims within the field of criminal justice, and finally to understand the victim support and the role of the criminal justice social workers within the system. When you talk about the victim, the 1985 UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power provides a broad definition of victims. And this definition says that victims means persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts of omission that are in violation of criminal laws operative within the member states, including those laws proscribing criminal abuse of power. A person may be considered a victim under this declaration regardless of whether the perpetrator is identified, apprehended, prosecuted, or convicted, and regardless of the familial relationship between the perpetrator and the victim. The term, according to this UN declaration, also includes, where appropriate, the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. So this is a really broad definition of victims, and it includes all categories of victims who suffer physical, sexual, or emotional or mental violence. When we look at the word victim, we could also categorize them in terms of primary and secondary victims. Who are primary victims? Those who directly experience the criminal act and face its consequences firsthand. Secondary victims are those who are not immediately involved or injured but are burdened nevertheless by the act of crime that is perpetrated. This would largely include family members and community members. There is also a concept of an ideal victim. Who is an ideal victim? Is there something like a concept called an ideal victim? Well, an ideal victim is somebody who is supposed to be powerless and undeserving of the victimization. That means somebody who had no role to play in his or her victimization. But there are some problems with this concept of the ideal victim, because this may end up leaving out some category of victims who did not fit the notion of what an ideal victim is. There is also a concept of victimless crimes, which means that these are those kind of victims where the victim himself or herself may not come forward and complain about the fact that he or she is being victimized. One example of this would be drug addiction, where the substance abuser, even though he or she is being victimized, will not come forward and complain that he or she is being victimized. When we talk about victims and the criminal justice process, we have to keep in mind that historically speaking, we have gone through 3 ages. One was the golden age of victimology, then the dark ages of victimology, and now the revival phase of victimology. The golden era is the age from time immemorial up until the last 200 years, when the victim had a very central place in the entire criminal justice system, which essentially means that we are talking about a phase whereby victim had a very important role to play in deciding the fate of the offender. This was also where community justice systems were in place, and victims and their family members were asked their opinion and views about what should be done about the crime that was committed by the offender. And they also had a role to play in deciding the punishment that should be meted out to the offender. With the coming of the modern criminal justice system, which laid focus and emphasis on rule of law and particularly on the rights of the accused, and when we moved into a paradigm of personal liberty under the modern notions of liberal democracy, this idea started changing, and gradually the victim started losing space within the criminal justice system, and the entire system became focused on offenders, accused people, and their rights and their duties and responsibilities. And this is known as the dark ages in the whole history of victimology. But then again, what has happened in the last 50, 60 years has been a revival of the victim justice movement, primarily thanks to the contribution of women's groups and other vigilante groups who have fought for the rights of justice for victims. The UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power emphasizes the following. Number one, that victims should be treated with compassion and respect for their dignity, that they are entitled to prompt redress, that the redress should be available both through formal and informal procedures, that victims should be informed about their role and the scope that they have within the system and the progress of the proceedings that are taking place in the criminal trial, and finally allowing victims to have their views to be presented and also having access to legal aid. When we look at the Constitution of India, there are a number of provisions, particularly in the fundamental rights and some in the directive principles, which talk about rights of victims. Article 14 talks about equal protection before the law. Article 21 includes compensation in criminal cases, compensation for custodial torture, fair trial and natural justice. And this is how the various Supreme Court and High Court judgments have incorporated all these elements within the ambit of Article 21. Article 17 abolishes untouchability. Article 23 prohibits human trafficking and forced labor. Article 24 prohibits employment of children. Article 38, which is in the directive principles, asks the state to promote the welfare of citizens. Article 46 talks about promoting education and economic interests of SCs, STs and other weaker sections. Apart from the constitutional provisions, you also have various special laws to protect the rights of various categories of victims. You have the Immoral Trafficking Prevention Act for victims of commercial sexual exploitation, the Juvenile Justice Act for victims of juvenile offences as well as children in need of care and protection. You have the Prevention of Child Sexual Offences Act, which talks about the sexual abuse of children. You have the National Legal Services Authorities Act, which talks about providing legal aid to all categories of people in need of legal aid. In the CRPC, there are some specific provisions which protect the rights of victims. Section 154 of the CRPC, in cases of crimes relating to crimes against women, the information is to be recorded in the presence of a woman police officer. For children, as per the Juvenile Justice Act, complaints have to be recorded in a place where the child is comfortable, in the presence of parents or social workers, etc. Then Section 164A of CRPC, which was amended in 2005, provides the procedure for the medical examination of a rape victim. Section 327(2) of the CRPC stipulates an inquiry into the trial and of a rape victim should be conducted in camera. Section 12 of the NALSA Act, the National Legal Services Authorities Act, provides that legal aid should be provided free of cost to any member from a vulnerable or marginalized population. For example, members of scheduled castes, scheduled tribes, victims of trafficking, women or children, persons with disability, victims of mass disaster, ethnic violence, caste atrocity, victims of floods, drought-prone areas, earthquakes or industrial disasters. All these people should be provided with free legal aid if they require it. There are also provisions whereby a magistrate may pass an order that the fine that is levied against the offender should be given towards compensation to the victim. This is under section 357 of the CRPC. 357A was inserted in 2009 to prepare a victim compensation scheme, and 357B and C were also inserted in 2013 pertaining to compensation in sexual assault cases and free medical treatment respectively. When we talk about the term victimology, which has emerged as a discipline separate from criminology in recent times, victimology can be seen as the scientific study of the physical, emotional and financial harm people suffer because of illegal activities committed by some people. Victimology is concerned about how victims are treated within the criminal justice system, what is the response of society towards victimization, and as an academic discipline, there are a few academicians who have played a very important role in expanding the scope of victimology. Two of these people require special mention, Hans von Hentig and Mendelsohn. Hentig wrote in his book Criminal and His Victim about the concept of victim precipitation. What essentially he was trying to say, which may sound a bit shocking, is that victims have a role to play in their victimization, which means that in his study he found that in most cases of violent acts, the victim had some role to play before the offender committed the violent act against the victim, and therefore this is known as a victim precipitation theory. Mendelsohn also follows this victim precipitation theory idea, and he has actually gone on to create 6 categories of victims. These categories are somebody who is called the completely innocent victim. That means the victim had no role to play in his or her victimization. Very young children who get sexually abused or physically assaulted can fall in this category. Victim with minor guilt, for example, someone who was attacked or robbed while walking through a crime-prone area or a badly lit area. So therefore, he had some role to play but not much in walking through that area. Voluntary victim, where the guilt of the victim is equal to the guilt of the offender. For example, people who are involved in a suicide pact, or a person who contracts a sexually transmitted disease after consensual sexual intercourse. A victim who is more guilty than the offender. Here we are talking about victims who have had a major role to play in provoking the offender to commit the crime. For example, a person who is being attacked or killed by a domestic partner after years of abusing that partner. Victim who is alone guilty. For example, an attacker who kills in self-defense. And finally, the imaginary victim, where there is, factually speaking, no victim, but the person falsely blames or accuses the offender of having committed some kind of violation against him or her. Then there's also Wolfgang's study, when he did a study of criminal homicides between 1948 and 1952, and he came up with the term called victim precipitated for the first time. And he said that it applies to those criminal homicides in which the victim is a direct precipitator in the crime. Victim precipitated cases are those in which the victim was the first to show and use a deadly weapon to strike a blow in an altercation. In short, the first to commence the interplay or resort to physical violence. His study showed that 26% of the cases that he studied were victim precipitated. Now, another area that we need to talk about when we are talking about this module is how do you measure victimization? Because in crime statistics, it is often said that it is the tip of the iceberg phenomenon, which means that the actual crime statistics that you see in any secondary data tables is only a very minute percentage of the actual amount of crime that may have taken place in that society. Therefore, there is a need to find other sources of trying to get a more holistic picture of the level of victimization in society. There are various surveys that are being conducted. Some are called the cross-sectional surveys, where you pick a representative sample from a geographic area and ask the sample of what has been their experiences of being victimized. There are appreciative studies which seek for qualitative description of the experiences of victimization. You have national sample surveys where you try to understand the various levels of victimization across the different parts of the country. And then you have cross-national surveys, which compares victimization rates between different countries. One common characteristic about all these surveys is that these are also known as self-report studies. Basically, what this means is that you carry out a survey where you go and ask random people from different sections of society whether they have ever been victimized, and if they have been victimized, what has been their experiences. So this is one more way of gaining and garnering data which otherwise is not available, because very small percentage of people actually come to the police to report about crimes. When we talk about theories of victimology, we have already talked about victim precipitation theories which were proposed by people like Hindelang, Mendelsohn and Wolfgang. There are also other theories. For example, there is Luckenbill's situation transaction model, whereby he says that homicide is a collective transaction where the offender, the victim and possibly an audience engage with each other, which leads to victimization. For example, what happens in communal riots and the final victimization that takes place, there is a history behind it whereby there is some kind of engagement between the victims and the offenders, as well as the social audience which is present in that society. The radical school of victimology actually focuses on what is the role of the state in producing victimization. For example, what happens in cases of fake encounters, whereby the state is actually responsible for victimization of people. Colzeridge et al. 2002 make some propositions of victimology in cases of state crimes. And what they come up with is some of the findings is that victims of state crime tend to be amongst the least socially powerful actors. That means they come from very marginalized sections of society. Victims of state crime are often blamed for their suffering. So typically, if you are again referring to the fake encounters, there's often a justification that they deserved what happened to them. Victims of state crime generally generally have to rely on either the victimizer or an associated institution or civil society movements for redress, because the state is not necessarily going to give them justice. And victims of state crime are easy targets for repeated victimization. The feminist theories have played a very major role in increasing the knowledge with regard to victimology, because feminist researchers really did research on cases of sexual assault, rape, domestic violence, and a whole range of crimes against women, which was earlier not studied because criminology was mostly male-centered. They have also been very critical of victim precipitation theories, because what they're saying is that when you talk about victim precipitation, you actually end up blaming the victim, because it in a way tries to say that she had it coming. Like for example, blaming the kind of clothes that the victim was wearing, or the place where the victim was found at the time of the offense being committed. So often some portion of the blame gets transferred to the victim, and this is something that feminist researchers have heavily criticized. They also have come up with the use of the term survivor as opposed to the victim, because there is a connotation of helplessness to the term victim as against the term survivor, which gives us a better and a more realistic kind of picture of the victim that we are talking about. They are also highly opposed to the idea of the ideal victim, as we have discussed earlier, because according to them, the ideal victim leaves out certain categories of victims who deserve help as much as anybody else. One of the most important contributions to victimology has been the structural theory of violence by Johann Galtung, where basically he said that there are two types of violence that takes place in society. There is direct violence and there is indirect violence. Direct violence is the violence that we see happening: physical, sexual, mental, torture, atrocities, crimes, etc. that we can see happening. But there is another kind of violence which happens against marginalized sections of society, because of the unequal power relations that exist in society, which we cannot see. And that is what he called a structural violence. For example, uneven distribution of resources, unequal access to education and health services, these kind of things, and especially for certain groups in society, for example, women, for example, Dalits, for example, people from tribal areas, for example, people from the marginal minorities. When this happens to such groups of people, it reduces their life chances in comparison to the dominant sections of society. And reduced life chances in turn makes them more vulnerable to other kinds of violence. There is also another kind of violence that Galtung talked about, which is cultural violence, whereby the ideology, the symbols, the philosophies, the norms, the values which are promoted by a society, which justify the structural violence that goes on in society and which ultimately leads to the direct violence also, is what is known as cultural violence. Then there are theories like the lifestyle approach by Hindelang, Gottfredson and Garfalo, where they say that victimization occurs when it is directly related to the time spent by a person in public places. The probability of being in a public place varies as a function of the lifestyle of the person, and individuals' chances of victimization are dependent upon the extent to which the individual shares demographic characteristics with the offenders. The proportion of time that an individual spends among non-family members varies as a function of his or her lifestyle. Variations in lifestyle are associated with variations in the ability of the individuals to isolate themselves from persons with offender characteristics. And finally, variations in lifestyle are associated with variations in the convenience, the desirability, and the visibility of the person as a target for victimization. In a sense, what they are trying to say is that depending on the kind of lifestyle you lead and the kind of places where you're found, your chances of victimization can increase or decrease accordingly. Now, when we come to the issue of crime prevention, we can refer to the 2002 UN Guidelines for Prevention of Crime, whereby prevention is defined as it comprises strategies and measures that seek to reduce the risk of crime occurring and their potential harmful effects on individuals and society, including fear of crime, by intervening to influence their multiple causes. In this context, it is interesting to refer to Lawrence Cohen and Marcus Felson's routine activity theory. What the routine activity theory tries to propound is that any crime takes place because of what they call as the crime triangle. What does it mean? They say that there are three elements when any crime has to take place: the presence of a motivated offender, the presence of a potential target, and the absence of the capable guardian. All these three factors together go on to a crime being committed. Lack of any of the above can lead to direct contact predatory crime, which means that if there is a motivated offender and there is a potential target, but there is also a capable guardian, then it's possible that the crime may not take place. But if there is a motivated offender and a potential target, but there is no capable guardian nearby, which means either neighbors or the police which can arrive at the spot immediately, then the crime can take place. Change in crime rates are linked to changes in the routine activity. So this is part of our routine life, when we may find ourselves in a particular spot when there is a motivated offender, and at that point of time I could be a potential target if I am vulnerable at that place. I may not be vulnerable in my own area where people know me, but I may be vulnerable in an area where people do not know me. And if the guardian is not available, which means in this case the police, then the chances of victimization are very high. Eck also adds that handlers to control offenders, whether there are people who can control the offenders, whether there are managers to control places, which means the police, and whether there are guardians to protect the victims, this could also have an influence in terms of the whole victimization process. There are various approaches to crime prevention. Primary approach would basically target the entire general population. Secondary approach would target the risk populations, both offenders as well as victims. Tertiary would target known victims and offenders. Like for example, senior citizens. Like Mumbai Police has a program whereby every senior citizen has to be registered with the local police, and they make visits to those police, to those homes. Environmental approach is where it is called also the situational crime prevention approach, which focuses on manipulation of physical environment, like for example, installation of CCTVs or improving surveillance through neighborhood watch programs. There's also this concept of hotspot policing, whereby the city can be mapped in terms of the high crime zone areas, and then increased patrolling can take place on those areas. In terms of social approaches, which addresses the criminal motivations or any program that can affect the behavior of the offender, the social crime prevention basically focuses on the potential the offender has through programs like improving the education level of the offender. What are the implications of understanding victimology? What implications does it have for social workers? Social workers would gain from the understanding that understanding the issues that victims face within the criminal justice system, and can influence policies and laws for victims within the CJS. Structures of victimization. What are the structures of victimization? And trying to understand which are the relevant populations, which are the vulnerable populations which need to be addressed when a social worker is working in this field. What is the role of community policing in this entire process? And what is the role in terms of crime prevention initiatives? In all these areas, social workers can play a very important role. So just to sum up, in today's module, we have tried to discuss what is victimology, who are victims, what are the theories of victimology, how do you approach this whole area of victimology, what are the various approaches towards crime prevention, and what is the role that social workers can play in this entire process.